All right, thank you everybody for coming out to our webinar. This morning, we're going to look at medical marijuana and fair housing, and that gets a lot of questions. So we're going to try to answer some of them. First off, can a housing provider, owner, management company, or a board of a condo or co-op association prohibit use of marijuana or evict someone for using marijuana? How about this? Is it legal for a tenant to grow marijuana in their rental unit if they've been prescribed medical marijuana? Or must marijuana be permitted as a reasonable accommodation? Here's what we're going to cover. Going to talk about just briefly the medicinal uses of marijuana. That's been a driving force in these changes. Then the classification of and proposed reclassification of marijuana as a Schedule 1 and to a Schedule 3 controlled substance. We're going to look at marijuana use and housing, and then requests how should it be handled to permit medical marijuana as a reasonable accommodation of someone's disability. First, the medical uses of marijuana. At the federal level, there's just issued recently, the Attorney General issued a notice of proposed rule to reschedule marijuana from Controlled 1 to Controlled 3 substance. And Attorney General acts on the basis of a report from Health and Human Services. Health and Human Services, dealing more from a medical background, found several uses of medical marijuana, helping with anorexia, anxiety, epilepsy, inflammatory bowel disease, nausea and vomiting, pain, post-traumatic stress disorder. Probably, right, none of this is any news to you or to me, right? There's been quite a bit. States have found medical use for marijuana. That's been quite often. And you can see the report here, since 1996, it's now up to 38 states and the District of Columbia. And 4 federal territories legalized the use of medical marijuana. I've got some of the listings in Michigan, and you can see Michigan, they list the debilitating medical conditions that qualify an individual for medical use. And look at all of them that are on there. That's a whole number of them, even broader than what we see from the DOJ or Attorney General in the notice of proposed rule to lower the classification for marijuana. Michigan has a marijuana regulatory agency, and you can see it has administrative rules, right? It has Medicinal Marijuana Act and rules. So Michigan's along with the other states. When you're up to 30 states, there's not much left. 12 states, that's it. So that's been a growing acknowledgement of the medicinal purposes of it. And so where's the question when it comes to the classification and the proposed reclassification? It is a Schedule 1 controlled substance, and there's a proposal to reclassify it as a Schedule 3 controlled substance. You see here in Congress in 1970 established the Comprehensive Drug Abuse Prevention and Control Act. And Title II of the Act is the Controlled Substance Act. So really, we just refer to CSA as the Controlled Substance Act. So the CSA came up with the 5-part classification schedules, ranging from Schedule 1, which is the most strict regulatory and criminal provisions or punishments, to Schedule 5, that those are drugs that are subject to the least regulatory and criminal provisions. So from the enactment of the CSA in 1970, marijuana was classified as a Schedule 1 drug. So that's been the case ever since. Now, there's different spellings of marijuana, but it's all interchangeable. So there's the citation at the bottom of the slide if you want to see that. So what's the importance of these drug schedules, right? There's several factors that they do. I'm not going to go into detail with it, but it deals with, for example, abuse potential, medical usefulness of the drug, and so forth, right? And important to note, especially the second paragraph, this came from the DEA's website, that a substance need not be listed as a controlled substance to be treated as Schedule 1 substance for criminal prosecution. Why? Because they can come up with new kinds of drugs, right? So substance analog is a substance which is intended for human consumption as structurally or pharmacologically substantially similar to, or is represented as being similar to a Schedule 1 or Schedule 2 substance and is not an approved medication in the United States. So that's something to be aware of. So here's the 5 schedules. This is as it exists today, and I've highlighted Schedule 1. You can see the reference to marijuana or cannabis as a Schedule 1 drug. And you look at the very top. Schedule 1 drugs, substances, or chemicals are defined as drugs with no currently accepted medical use and high potential for abuse. And marijuana was listed there, and that was the view in 1970. Then there's Schedule 2 drugs. Schedule 3, I'll take a look at Schedule 3 because that's the consideration of reclassifying marijuana. Schedule 3 drugs, substances, or chemicals are defined as drugs with a moderate to low potential for physical or psychological dependence. Schedule 3 drugs abuse potential is less than Schedules 1 and 2 drugs, but more than Schedule 4. Some examples are products containing less than 90 milligrams of codeine, Tylenol with codeine, and so forth. You can see those, right? So historically, up to the current time, marijuana was viewed as not having any accepted medical use. States, obviously, overwhelming majority would disagree with this. So what happened is just recently, the Department of Justice proposed to transfer marijuana from Schedule 1 to Schedule 3, right, of the Controlled Substance Act, or CSA. Now, with the Attorney General, Department of Justice, Attorney General synonymous, the Attorney General, on behalf of the Department of Justice, has to make a request to the Secretary of Health and Human Services, HHS, for a scientific and medical evaluation, and the Secretary of HHS recommendations whether a drug or substance should be controlled or removed as a controlled substance. And then in August 2023, HHS recommended that marijuana be rescheduled to a Schedule 2 drug or controlled substance. Now, the DOJ, May 21st, 2024, agreed with the position of the HHS and found that marijuana has currently accepted medical uses, and those include the 7 that I mentioned previously. The DOJ also concurred with HHS's views regarding about marijuana's abuse potential and level of physical and psychological dependence. They did not see it or did not view it as having the potential for abuse and physical or psychological dependence to put it in the category with the rest of the Schedule 1 drugs. So that's where it stands. I think the due date for comments to the notice of proposed rule is late, sometime in July next month. And then at any point in time, they'll act on it, promulgate a final rule, taking it into consideration the comments that are received. And then the justice turns to propose the new rule, final rule, over to the OMB. And the OMB can take up to, I don't know, 3 to 6 months. It depends. Published. The final rule gets published in the Federal Register. So it's still months away, many, many months away before that classification occurs, should it occur. My gut feeling, very likely to be reclassified as Schedule 3. So here's why we're here. Marijuana and housing. How is this handled? Well, HUD has written a lot on this when it comes to federal, public, and assisted housing. You can see 4 statements by HUD. The earliest one in the bottom left, HUD memorandum, medical use of marijuana in public housing. We're going to go through all of these. Then HUD they did another memo January 20th, 2011. Then there were 2 more recent ones, still kind of dated, but February 10th, 2021, and then December 29th, 2014. So HUD's written a lot on this, right? So the first memorandum, the Public Housing Reform Act, this is a 1991 HUD memorandum. The Public Housing Reform Act governs admission and termination standards for public housing agencies and owners of federally assisted housing. They're required to prohibit admission to those who are illegal using a controlled substance, and it gives them a requirement to terminate tenancy for drug abuse by a household member, that it interferes with the health, safety, peaceful enjoyment of the premises by other residents. Now, here's a real key point here, is that the CSA defines controlled substance as a drug or other substance or immediate precursor included in Schedules 1 through 5. So if it's listed in Schedules 1 through 5, it's a controlled substance. It doesn't distinguish between, for example, if marijuana now covered under Schedule 1, including Schedule 1, if it's shifted to Schedule 3, really doesn't make a difference when it comes to Public Housing Reform Act because it doesn't distinguish between the various schedules of controlled substances. And HUD in 1991 said that state statutes that purport to legalize marijuana stand as an obstacle to accomplishment of the purpose of the Public Housing Reform Act, PHRA, meaning the purposes require owners of federally assisted housing to establish standards prohibiting admission to federally assisted housing, right? In the two categories of household, those that are applicants that are using illegal drugs or at the application stage or while they're occupants using it. And because of that, the conclusion by HUD is that it preempted state local law that would be legalizing marijuana. In other words, it has no effect when it comes to public housing. On each of these, there's some discretion. I'm going to note them all the way through. It says federal law preempts any discretion on the part of the public housing authority or owner from determining that medical marijuana is not a controlled substance. Therefore, an owner or PHA could not make a determination that the use of medical marijuana per se is never grounds for termination of tenancy or assistance, and consequently could not establish standards or lease provisions that generally permit occupancy of federally assisted housing by medical marijuana users. However, it did say it permits case-by-case determination when it's appropriate to terminate a tenancy or assistance under a voucher program of assistance to a household. And it also emphasizes that PHAs and owners can all still admit households if there's a record of criminal activity when there's been, I should say, drug-related activity, when there's been evidence of rehabilitation and no current illegal use. And you see the two sections, 42 U.S.C. section 13661 subsection B2, that deals at the application stage, and section 13662B is the one that deals with termination of a tenancy for use of illegal drug use. So there is discretion there. And I didn't get into it, but for more background in that, you can go to the HUD's Public Housing Handbook. Has all kinds of discussion when it comes to criminal activity and drug use. So that's 1999. HUD reaffirmed this in January 20th, 2011. It reaffirmed the September 1999 conclusions. It says that federal and state non-discrimination laws do not require public housing agencies and owner of other federally assisted housing to accommodate requests by current or prospective tenants with disabilities to use medical marijuana. Then it restates, well, it doesn't state it, it emphasizes that use of medical marijuana as a reasonable accommodation is not covered under 504 of the Rehabilitation Act and the ADA because persons who are currently using illegal drugs, including medical marijuana, are disqualified from protection under Section 504 and the ADA. If someone is a current illegal user or abuser of drugs, they're not covered. They're also not covered under the Fair Housing Act as well, although they don't have that language here. In terms of reasonable accommodation under the Fair Housing Act, they said that to require the use of PHAs and owners to permit medical marijuana would constitute a fundamental alteration in the nature of a PHA or the owner's operations. So that's a very firm line in the sand. So they may not grant requests for reasonable accommodations, and it also directs HUD, Office of Fair Housing Opportunity, FHEO, who receives fair housing complaints, should not issue determinations of reasonable cause that a Fair Housing Act has been violated based solely on the denial of request to use medical marijuana as a reasonable accommodation. And the term individual with a disability, you can see the language here under the ADA. It does not cover someone who's currently engaged in illegal use of drugs when the covered entity, meaning the PHA or owner, acts on the basis of such use. The second citation, 28 CFR section 35.131A1, that's I believe, that's Rehabilitation Act regulation. It says this part does not prohibit discrimination against an individual based on that individual's current illegal use of drugs. Now, there is door open a little bit for some discretions. And in the 2021 memo, it said, while PHAs and owners can't grant reasonable accommodations for medical marijuana, they can exercise discretion deciding to evict or refrain from evicting current residents who are using medical marijuana. So that's the first two. There's two more. And then for use in public housing and housing choice voucher program. This is February 2011. Made clear, very short memo. Governs has addresses new admissions and current residents. And so based on federal law, new admissions of medical marijuana users are prohibited into public housing and housing choice or Section 8 voucher programs. Because again, CSA lists marijuana as a Schedule 1 drug. Quality and Housing Work Responsibility Act, the same section, Section 42 United States Code Section 13661 requires them to prohibit anybody from admission based on illegal use of controlled substance, including state legalized medical marijuana. And it held to the position that because states have legalized medical marijuana, to give credence or weight or to follow state legalization of medical marijuana would directly conflict with the admission requirements set forth in QHWRA, Quality Housing and Work Responsibility Act. Again, that's the law that governs public housing. Now, for current residents, the law requires public housing agencies to establish occupancy standards, which permits termination of assistance or rental for use of controlled substance, but the law doesn't require it, and public housing authorities have discretion to determine to permit continued occupancy that are most appropriate for their local communities. For example, they can deny assistance or terminate individual medical marijuana users rather than evicting the entire household. To emphasize, again, it's a matter of discretion whether to allow or not allow continued occupancy or assistance to medical marijuana users. It's responsibility of PHA, not HUD. HUD's not going to get involved in that decision. So, kind of getting repetitive, I suppose. Then HUD, the last one is HUD memorandum in December 2014. It restates the point that the CSA, again, the Quality Housing Work Responsibility Act is the main law. Title II, a Controlled Substance Act, categorized medical marijuana as a controlled one substance, and therefore manufacturing, distribution, or possession of marijuana is a federal criminal offense. It's illegal under federal law. So therefore, what? Any questions regarding the use of marijuana is determined by federal law, not state law, and owners of federally assisted housing are required to deny admission of any household is at the time of application illegal using a controlled substance defined under the Controlled Substance Act. Now, they do note that since the 1990s, a number of states had legalized marijuana, right? But regardless, that it's been legalized under state law, the use of marijuana in any form is illegal under the Controlled Substance Act, and therefore is a legal substance under the Quality Housing and Work Responsibility Act, QHRA, in 42 U.S.C. Section 13662. Where's the discretion? Owners must deny admission to housing for anybody determined to illegally using a controlled substance. They cannot put lease provisions that would permit occupancy by any member of a household using marijuana, and they have to establish policies to allow termination for those illegally using marijuana, provided it interferes with the health, safety, or right to peaceful enjoyment of other residents. However, the emphasis is that Section 577 affords owners the discretion to evict or not evict current tenants for their use of marijuana. So that's clear established position of HUD, bound by the statute. I mean, it's what Congress has determined. Unless Congress changes it, HUD is duty bound to follow it. Michigan addresses this under landlord-tenant law. There's two laws, Michigan Regulation and Taxation of Marijuana Act, known as recreational marijuana. It made marijuana legal under state and local law for adults 20 years of age and older, and to control the commercial production and distribution of marijuana under a state system that regulates it, licenses it, and so forth. So it allows a person A landlord, for example, to prohibit or otherwise regulate consumption, cultivation, distribution, processing, sale, or display of marijuana accessories on the property that the person owns, occupies, or manages, except that a lease agreement may not prohibit a tenant from lawfully possessing and consuming marijuana by means other than smoking. So if someone has medical marijuana in Michigan, you can prohibit the smoking of marijuana, provided it's in the lease agreement, but you cannot bar them from using medical marijuana by means other than smoking. And the Michigan Marijuana Act states that it cannot be construed or will not be construed to require a private property owner to lease residential property to any person who smokes or cultivates marijuana on the premises if the prohibition against smoking or cultivating marijuana is in the written lease. The legislature kind of balancing rights of landlords, other tenants with marijuana use with the rights of person with a medicinal need for marijuana. And that's how Michigan has struck that balance. Again, this is separate from federal requirements. Now, by the way, I'm talking a lot about the federal requirements. Do they apply in private housing? Well, no, not strictly. Let me come back to these, right? That's federal public and assisted housing. So it's binding. These sub memorandums are binding. It controls how public housing and assisted housing, what the standards are for admission and termination of occupancy. However, private landlords, housing providers are free to use these policies for their own housing, right? And many do it by, for example, find it easier just to have a no smoking rule would be an easy way. And then you don't get into all the questions about whether someone can use medicinal marijuana or not. If there's just a broad non-smoking policy, it may address many of those concerns. Our next question is this: how do you handle requests to permit medical marijuana as a reasonable accommodation of a disability? HUD Memorandum, January 2020 notes, commensurate with the relatively recent upsurge of states passing medical marijuana laws. That's now obviously an understatement. There's been a significant increase in the number of requests by residents of those states for exceptions to federal drug-free laws and policies to permit the use of medical marijuana as a reasonable accommodation for their disabilities. So federal law, reasonable accommodation requests, because marijuana is banned by federal law, it's within the illegal use of drugs exclusion to the ADA. The ADA does not afford protection to someone who's currently involved in the illegal use of drugs. Therefore, there can be no federal ADA claim raised. Under the Fair Housing Act, the Fair Housing Act likely do not apply. Cases under the Fair Housing Act apply ADA standards. If it's not covered under the ADA, if someone is not protected under the ADA, they're not going to be protected under the Fair Housing Act. In another way, the Fair Housing Act excludes from protection those that are involved in the current illegal use of drugs, and so would not be covered under the Fair Housing Act. And the cases that have denied them, you can see I've got James versus City of Costa Mesa, Assenberg, Ninth Circuit case, couple Ninth Circuit cases, Kind and Compassionate versus City of Long Beach, California case 2016, and then Forest City Residential Management, Eastern District, Michigan, 2014. We'll talk about that in a second. Case that did grant the request, Cease versus Housing Authority. It was a Pennsylvania Commonwealth case in 2021. So let's take a look at these. First case, Cease versus Housing Authority, Pennsylvania of Commonwealth. She was a 61-year-old disabled veteran. She was denied her Section 8 housing because she disclosed that she used medical marijuana instead of opiates to mitigate her constant back pain. She had had several surgeries. The Public Housing Authority concluded that her medical marijuana violated the CSA. So they're applying, obviously, HUD standards, denying tenancy. The court, however, found the authority must establish standards for determining when and on what basis admission is prohibited for a Section 8 housing applicant who the authority determines is illegally using a controlled substance. The court articulated the following standards that the housing agency should take into consideration: the nature of the substance, whether the use is clearly unlawful or in an unclear legal state, such as there in Pennsylvania, as the state had legalized its use, the reason for the substance use, whether it's being used in accordance with legal requirements, medicinal purposes, and the applicant's background, behavior during the prior tenancy, and the presence or absence of any prior criminal record. Here, she had no prior criminal record. The court noted that the term illegal using a controlled substance was ambiguous in the context of the case where the use of medical marijuana was prohibited by federal law, yet permitted under state law. And in further reason, the court, while possession and use of marijuana remains illegal under federal law, even for medical purposes, the federal CSA, Controlled Substance Act, does not and could not require states to enforce it. According to the court, the provisions of the QHWRA are based on obsolete, scientifically flawed premises that marijuana has no currently accepted medical use in treatment. And that is kind of the idea that the Attorney General and through the DOJ is trying to reclassify it from Schedule 1 to Schedule 3. Question is what? Is it override federal law? Not so sure about this decision, but it's important to really think about a decision like this because there are going to be more. The second case to take a look at is Forest City Residential Management versus Beasley. This was decided in Michigan Federal District Court in Michigan. Forest City manages several complexes, several that participate with federally subsidized housing programs. Beasley resides in one apartment unit managed by Forest City that holds a medical marijuana card, been smoking marijuana in her apartment, and she requested as reasonable accommodation that she be allowed to use her medical marijuana in her apartment. Beasley was diagnosed with MS in April 2009 SSI. Her prescription prescribed medical marijuana to help her with multiple sclerosis. She obtained a medical marijuana card issued by the state of Michigan pursuant to the Medical Marijuana Act. So all those facts were undisputed. And here's some of the language in the case. Plymouth Square project-based Section 8 federally assisted housing complex. And the lease agreement provides that the landlord, Forest City, doesn't say they must, but may terminate for drug-related criminal activity. And if the landlord determines a resident or any member of the resident's household, a guest or other person engaged in criminal activity or been arrested or convicted for such criminal activity, that they may terminate the lease. It's right there in the lease, spells out what the HUD requirements. The lease further states that drug means controlled substance defined under Section 102 of the Controlled Substance Act. Notice that is broad, doesn't distinguish between the various schedules of controlled substances. Drug-related activity means the illegal manufacture, distribution, or use of a drug, or possession of a drug with intent to sell, manufacture, sell, distribute, or use the drug. The housing provider went into court and wanted to know if it was permitted to do so. It wasn't a situation where the tenant brought the case to sue for denial of reasonable accommodation. Here, the housing provider went into court to ask for guidance on what the standards should be. The same day she signed her lease, she also signed a tenancy termination provision for housing, for HUD housing, addendum for housing programs, and it states that the landlord may terminate for various reasons, including what? Drug-related criminal activity or a household member illegally using a drug. Signed, initialed by Beasley. She put her name next to it. So what did the court say? Would requiring a reasonable accommodation fundamentally alter the nature of a program? Basically, it said it would. It would, right? Congress has clear policy behind the Section 8 federally assisted housing program, and the court gives deference to HUD's interpretation of the Fair Housing Act. Basically said because it's section of the Federal Controlled Substance Act impliedly preempts the Michigan Medical Marijuana Act. In other words, a housing provider can't comply with both. Can't allow medicinal marijuana under Michigan law while at the same time follow HUD standards for public housing or the standards set forth by Congress in the law governing public housing. Turning to the court alone on that basis found that they weren't entitled to a reasonable accommodation for medical marijuana under the Fair Housing Act. always for a reasonable accommodation under the Fair Housing Act, there's two parts. There's necessity, showing that the person with the disability needs the reasonable accommodation for a medically related reason. And right here, I don't know if it was, I don't think it was contested that much that she needed medical marijuana to assist with her medical condition. But the second part of is reasonableness. Is it reasonable for a housing provider to have to grant the reasonable accommodation? If it will result in a fundamental alteration in the program that's being offered by the housing provider, then the reasonable accommodation request will be found to not be reasonable. And that's what they did here. To grant the reasonable accommodation request would require the housing provider to not follow congressional, statutory, HUD's regulatory 24 CFR 880.101, so forth, standards when it comes to administering their public housing program. And you can see the regulations there, 24 CFR section 5.854B1, 24 CFR 5.854B2, and so forth. It said it would disrupt, fundamentally alter the nature of their programs. So there was not, BZ was not be entitled to a reasonable accommodation under the Fair Housing Act. Then when it comes to the Rehabilitation Act, the term disability, it's defined physical mental impairment, substantially limits one or more major life activities. However, individual with disability does not include an individual who is currently engaging in the illegal use of drugs when a covered entity acts on the basis of such use. So therefore, because the use of it is not legal under federal law, then she's not protected under Section 504 of the Rehabilitation Act. So there's no right to a reasonable accommodation for medical marijuana under Section 504 of the Rehabilitation Act. Let's go to the questions. Can an owner management company or board of a co-op or condo association or other housing provider prohibit the use of marijuana or evict someone for using marijuana? Yes. Use of marijuana, a Schedule I controlled substance, is unlawful under federal law. Is it legal for a tenant to grow marijuana in their rental unit if they have been prescribed medical marijuana? No. Same answer. As long as marijuana is classified as a controlled substance under federal law, the growing or other use, even as medical marijuana, is unlawful under federal law. And again, we saw previously under Michigan law, someone can restrict use of marijuana, right, from growing and so forth, except under Michigan law, you can't restrict it by means other than smoking. Must medical marijuana be permitted as a reasonable accommodation of a tenant's disability? Nope. As a controlled substance, use of medical marijuana is not protected under the ADA or the Fair Housing Act. Must medical marijuana be permitted as a reasonable accommodation of a tenant's disability? No. As a controlled substance, use of medical marijuana is not protected under the ADA or the Fair Housing Act. However, and this is a real proviso, challenges are likely forthcoming if and when marijuana is reclassified as a Schedule III controlled substance. The argument will be that a disabled resident with a disability who's been prescribed medical marijuana by a qualified medical provider is not an illegal user or abuser of a controlled substance for purposes of the FHA or ADA. Challenge is certain to occur. Count on it. Like in the Pennsylvania case that was brought under state law, I would expect it in every single state, these kinds of challenges to be brought. Why? Because reclassifying it from marijuana from Schedule I to Schedule III is based on the idea that it does have medicinal purposes. That's an acknowledgement at the federal level. So therefore, it seems reasonable for healthcare providers to prescribe medical marijuana. In such case, it becomes difficult to challenge it, right, as constituting the illegal use or abuse of a controlled substance. I'm not saying it's rock solid, but it's an argument to be made, and it's going to wait. There will be court cases on this. So what's the thing? Caution. Caution by a housing provider because tenants are going to ask for it. Safest approach, non-smoking policy, allow it to be used in non-smoking for medicinal purposes. Beyond that is up to the discretion of the housing provider, obviously. We get constant questions, requests, comments, right, when it comes to medical marijuana